Hi, I'm Gregory Dell, and I'm here with attorney Stephen Jessup. Good afternoon, Steve.
Good afternoon, Gregory.
And today we're going to talk about the Standard Insurance Company and specifically their handling of long-term disability insurance claims. Now, Steve, I know you've been involved in quite a few claims against the Standard, and on a few occasions I've been out to Portland, where their headquarters is, to take some depositions of some of their folks in the litigation of cases. But I want to focus a little bit on and they have individual disability claims that are non-ERISA, but I want to focus a little bit on their handling of ERISA claims. And, you know, we handle claims with 40 different disability insurance companies, and Standard in particular has their own nuances of how they're set up, and there's a lot we know from taking the depositions and getting their internal claims handling and all of those things. What is it specific about what a person should expect with a Standard, you know, the review by Standard of an ERISA denial?
The review, it's kind of hit or miss. Sometimes I see very thorough reviews, and sometimes the denial letters are very, very lengthy and involved. But for as many as you see on those, you see somewhere, they had maybe just a doctor review some records, upheld the denial. So it kind of runs the spectrum. And I think it really comes down to the claims person, how much grief they're legitimately going to give you, and in the context of the policy language, because they do write some interesting policy language that other carriers don't. For instance, evidence of physical disease, and the way they define physical disease creates a need for objective medical evidence in their policies. So it really depends. You can have very, very thorough reviews, where they'll conduct, various reviews with professionals, or simple line item denial of benefits. Just, we just don't think you're disabled.
You bring up a good point. You're right on with the fact that, sometimes their reviews are only as good as the employee who is either the appeal specialist or the underlying claims consultant who's reviewing the file. Because sometimes I look at it and I go, wow, this person really did. They hired 4 or 5 doctors. They did an exam of the person. They got video. They did it, all this stuff. And it could be like a $2,000 a month benefit. And then I'll get the $15,000 a month benefit.
And it's a very, the doctor, we had an independent doctor look at it, and he didn't find restrictions and limitations, and it's denied.
Right. So Standard definitely knows the right way to review a claim. They're not one of the companies that you commonly see tons of Department of Insurance complaints.
Correct.
Or they're engaging in, unfair and deceptive practice or something like that. It's not common. They're not one of the big 5 problem makers.
Or you're not seeing the boilerplate denials, where it's just they cut and paste the same language in every letter.
Right. And on I do recall that many of their people who do the claims are actually well educated, as opposed to what you may see at some of the other companies. So that being the case, it is kind of hit or miss, but when they do make a mistake on a claim and we're handling a client and we bring it to their attention, they will often hold themselves accountable for the mistake, whereas there's other companies who don't. They can't get out of their own way. No matter what, they won't admit, oh, we made a mistake here.
I would say by numbers, filing of lawsuits against Standard, I would say, are numbers-wise, for me personally, much less than, say, your Cignas or your Hartfords and those insurance companies. So I would agree that on an appeal and presenting the information, they really do thoroughly will start to review that, and consider the facts.
Right. And the other thing, which is, glimmers of hope and optimism for people considering hiring our firm who have been denied, is that I think our success rate on Standard claims is much higher than most of the other carriers, and that's on an appeal.
Correct. I would agree.
So that's great. So I'm encouraged when somebody calls us and says, hey, I've been denied by Standard. First thing I'm thinking when they say I've been denied by whoever it is, I'm like, don't say, a handful of companies, and then they say Standard, and I go, okay, we have a chance, because I feel like they're probably going to get a fair review of their claim, whereas many others I may feel like you may not have a fair chance to get your claim reviewed. In terms of your experience of losing an appeal, or someone calls us after they've already exhausted all their appeals and then you have to file a lawsuit against Standard, how has that experience been for most of your clients?
I would say that the vast majority of the clients, the matters are usually resolved one way or another. They do hire very, capable attorneys. I found that the in-house attorneys, and they contact people within it during the course of mediation, are very professional. They do, they are, I don't know how much I would say understanding, but they are more willing, it seems, to admit potential weaknesses and chinks that they may have when they want to discuss the matters. So although it is ERISA-based litigation, so there's always their difficulties that come with it, I feel that, as you had said, the claims handling you see, usually they require, higher education of sorts, so they're better prepared. And I would say that in the process of litigating it, that level of professionalism seems to permeate up as well.
I think that someone who's considering hiring a law firm needs to really question that particular law firm, whether it's us or whoever it is. How many cases have you handled against Standard? How often have you taken depositions of them? How many times have you actually filed motions against them and litigated against them? And how many claimants have you had approved versus denied? And obviously we have all that information. The numbers are significant for us in terms of answering all those questions, but whether it's Standard or any company, it's really important that this is the type of work that you do, and it's not just, oh yeah, I can handle your Standard and claim, because if you hire a lawyer who doesn't know what they're doing, it's really hard. And we often get the cases after a lawyer did an appeal, and then they either send it to us or they go, my lawyer lost, what can you do? So that's tough. And in terms of the litigated issues that we see, it's almost always a lot of the same things because of some of that restrictive language you talked about in the policy. Like, for example, the way they define occupation. What's a little bit different about that, their definition?
Their occupation, and a lot of them, in some policies, I've seen older policies where it's not as clear-cut as newer. They kind of take the tone of a national economy standard, so they're not going to look at how you performed your job for your specific employer so much as how you performed it or how it's performed in the general national economy. Most of the denials I do think that you will see, I think by numbers, a lot of the any occupation denials, when the standard is going to change for you as to how they have to evaluate what you may be able to do and not do based on restrictions and limitations. So you always got to work against this national economy standard. And that's why I find that a lot of the argument, and especially in the appeals I've done in cases had to litigate, it was not so much an argument with regards to the medical as opposed to the occupational aspects of it.
And very often I know that Standard is specifically employs vocational consultants in-house, whereas many companies don't have that resource to determine what the requirements are for particular jobs, what the labor market evaluation is, meaning what are the jobs that are actually available once they determine what the jobs are. So they try to cover that base. Fortunately for claimants, they often, when we see those, they don't do the best job at determining the types of jobs that are available or what the person can do. So those are, our job as lawyers when someone's denied is to find all of the things that the company did wrong. What could they have done better? What did they fail to do that would have been reasonable, and then present that for them. And most claimants, there's no way they can know. They don't do this day in. It takes years and years and years to learn the whole gamut of what's available and then be able to advocate that position and present that on behalf of the claimants. So whatever stage your claim's at, whether application, it's a denial, you have to file an appeal, or you have to file a lawsuit, no matter where you live, anywhere in the country, we handle cases throughout the United States. Give us a call, we'll review your claim, give you a free consultation, and let you know right away whether or not we can assist you.